Hi, I'm Mike Papantonio, and this is America's Lawyer. DuPont's one of the largest and longest operating corporations in America. And for more than 50 years, they dumped a poison, a substance known as C8 into the Ohio River. That chemical went on to poison thousands of Americans, causing cancers, thyroid disease, and intestinal disease. DuPont knew about those dangers for decades, but they continued to keep the public in the dark about the true nature of these chemicals. But their luck has run out, and juries are siding with the injured victims in cases that have already gone to trial. Today we'll be looking at the toxic history of DuPont and how traces of their poisons can be found in almost every single person living in the United States. And later in the show, I'll be speaking with attorney Gloria Allred about the Bill Cosby sexual assault case. So don't go anywhere. America's Lawyer starts now.
This is a classic whistleblower case within the pharmaceuticals. Fraud is comments by this company was what you're doing is wrong.
C8 is a product that the DuPont Corporation used to manufacture Teflon. In the process of manufacturing Teflon, DuPont pumped millions of pounds of C8 directly into the Ohio River, and that cancer-causing toxic ended up in the drinking water of more than 70,000 residents along the Ohio River, all along the valley. Not only did the cancerous toxin end up in the drinking water of men, women, and children along that Ohio Valley, it also ended up, and it's going to remain in that population's blood for 20 to 25 years. The biggest problem with having that poison in their blood is that it causes cancer. As a matter of fact, a federal judge had a team of specialized epidemiologists study the damage that the C8 poison causes to the human body, and that team concluded that the C8 poison that DuPont dumped into the Ohio River starting in 1950 caused kidney cancer, testicular cancer, and a host of illnesses that can be fatal. Here's what we know. As early as 1961, DuPont toxicologists reported that the C8 poison used to produce Teflon was producing extreme liver abnormalities in laboratory animals. Even as early as 1961, DuPont was telling their own employees that C8 should be used with extreme care. But you know what? They didn't tell the public that. They kept it secret. And then by 1988, DuPont was warning their own employees that C8 could cause cancer. But again, they weren't telling the public. They wanted to keep that secret. And then again, in 1997, DuPont told their employees that C8 could cause cancer again. But again, they kept that secret from the men, women, and children who were drinking the contaminated C8 toxic water every single day. The documents clearly show that DuPont had a reason to keep the toxicity of C8 a secret. As a matter of fact, when you go back and look, this document shows as early as 1992 that DuPont was concerned that their C8 contamination would become their #1 personal injury concern. But still, they continued to keep that information secret from the people who were drinking the water every single day. So by 2001, DuPont's chief in-house lawyer predicted that when the public found out about why and how these people were contracting cancer, that DuPont would be hit with punitive damages by a jury. That lawyer, he was ignored. They didn't listen to him. And just last week, a jury in Columbus, Ohio, punished the DuPont company for their reckless, conscious disregard for the safety of health and safety of the entire community who drank that water. A jury returned a verdict against DuPont for $12.5 million. That jury saw documents like the one on the screen that shows that DuPont scientists were so concerned about the dangers of C8 that high levels of C8 might require the public to actually wear gas masks in order to live safely along parts of the Ohio Valley. The bad news is that the incriminating and remarkably callous documents went downhill even from that. To talk about DuPont's poisoning of the Ohio Valley is Gary Douglas, one of the trial lawyers who tried the case against DuPont last week. Gary, take us all the way back to the beginning of the C8 story. What is this chemical, and why did DuPont start using it to begin with?
Well, Mike, you know the story well, and by the way, thanks for having me here. And I guess it goes back to the 1950s when this miracle concept of a Teflon pan and the non-stick pan was going to change everybody's lives in the old good old days of the 1950s. But what was happening secretly behind closed doors in DuPont's laboratories as they made billions selling Teflon was they needed this chemical C8, which, as you know, is a poisonous and causes cancer. They needed this chemical to make the product. And behind closed doors in their secret laboratories, they understood way back in the late 50s and early 60s that it was potentially toxic and possibly may cause cancer. So they started over decades to conduct a series of tests in laboratory animals, from rats to rabbits and beagles and monkeys, and you know this story well, Mike. And they got the news that they didn't want to have, which was that it was, in fact, something that can cause cancer and was extremely harmful to people, especially if it got into folks' drinking water, which, as you know, and as you explained before, they were dumping it by the tens of thousands of pounds into the Ohio River and emitting it from their massive smokestacks into the sky, and it made its way across the river into the well fields where people, innocent folks, would get their drinking water from. And that's how this whole story unfolded, Gary, and it was kept secret.
What you were able to show in trial, you actually have hit DuPont. You've hit them 3 times. I think the first time you hit them for $1.6 million. The second time you hit them for $5.6 million. This time you hit them for $12.5 million. After handling those cases, is it apparent to you that after very few years, the company understood that their own studies showed that C8 was a compound that was poison and would potentially cause human disease? Was there any question that a jury had to wrangle with in the cases that you've tried?
There's no question, and I think the reason for the increase in the verdicts is because we're learning how to deal with how they have tried to defend and obfuscate the truth over the years. I like to say they're in the business of manufacturing deniability, and rather than own it and step up to the plate and be transparent with the folks who are drinking their poison, who are unknowingly drinking their poison, they went about a strategy to hide and obfuscate and create deniability and do studies where that were designed to find nothing. And they hid the fact for years from these poor innocent folks that C8 was in their drinking water.
Gary, you have about 3,700 cases just in Ohio Valley right now. You've shown this company time and time again that juries just are furious once they hear the facts. What is the company softening on their position? Are they trying to do the decent thing, and that is to pay these people for their cancers and their thyroid disease and all of the ulcerative colitis disease that they're suffering from?
Unfortunately, Mike, I don't think so. I think this is one of the most egregious cases of corporate malfeasance in the history of America, and I just think it's a corrupt corporate mentality where they have for decades dug their heels in to fight this, and they just can't get past themselves, and they continue to dig themselves in. We hope that with these verdicts, one after the next and one after the next, that some folks at corporate headquarters are going to wake up and say, well, what the heck is going on here? It's time to do the right thing for these poor folks in the Ohio Valley.
I heard about the job you and a lawyer from our firm, Wes Bowden, did in that case up in Columbus, Ohio, this last go-around. And I think what they were most concerned, the jury apparently was most impressed with, was your level of rage at what you had seen. And you talked about in one of your closings the fact that one thing that made you so angry was the fact that this is a biopersistent poison that's in these people's blood for 20 to 25 years. Talk about that a little bit.
Well, you mentioned a little bit about the outside of the show, and I just got to say, by the way, you mentioned Wes Bowden, who is a terrific trial lawyer, and couldn't have had this last victory in court without him. But the biopersistence is something that resonates with folks, because as we're sitting there in court, and our client, Kenny Vigneron, his cancer was diagnosed in 1997. He still has this cancer-causing chemical all of these decades later coursing through his blood. And this is something that I think resonates with jurors or anybody who has a sense of some sort of decency. Because they didn't just pollute the river, they polluted people, and they didn't just pollute people, they polluted them with a chemical that will not leave their body for decades. And so you have to walk around for decades knowing that this chemical that may cause cancer is still coursing through your blood. And it just resonates with jurors, and it is easy to get enraged and angry when you're trying a case like that.
Well, they said your closing argument was superb, and I've seen that anger before, and I know in this case it simply is appropriate. But I'm wondering about how this started in 1950. How is it that corporate media never reported this story? And they're still really underreporting this story about how serious this is. What's your take on how that happened? Why is there no story out there from corporate media?
Well, of course, it doesn't help the corporate America for jurors and folks to hear about stories like this and how things really work, and that chemical companies like DuPont just about have free reign. You think that the EPA is out there, we'd like to think anyway, the EPA is out there and our government's out there protecting us from companies that may dump harmful chemicals in our drinking water or pollute the air. But the fact is there's so much, there's only so much that they can do. And these corporate entities like Dow, DuPont, you name the company, they're so entangled with the regulators that these stories get suppressed. And I think just folks get desensitized to this. We've heard so many stories of these like this that it's just hard to get traction amongst the regular folks. But again, it's like folks like you, Mike, and you failed to mention that we tried those first two cases together, and you're a great mentor of mine, and you know that one of the ways to get the message out is to try these cases, and that's what we're doing.
Gary, I got to tell you something. I really mean this. I honestly believe you're one of the best trial lawyers in this country, and it pleases me to know that you're out there going after DuPont. I know the people in the Ohio Valley are going to get justice, and on behalf of those people, I certainly thank you for the effort that you showed in this last trial. Thank you very much, Gary. Thank you for joining me.
Thank you, Mike.
Coming up, I'll speak with attorney Gloria Allred about the Bill Cosby sexual assault case. Stay tuned.
For decades, the American middle class has been railroaded by Washington politics. Big money corporate interest has drowned out a lot of voices. That's how it is in the news culture in this country now. That's where I come in. I'm Ed Schultz. I do the news on RT America. I'll make sure you don't get railroaded, and you'll get the straight talk and the straight news. Question more. Earlier today, President Obama...
Senate Republicans previously stated that the component responsible for poisoning people in Flint.
There is always hope.
That's what goes
Trump
on
is
in
making a lot of
politics.
noise
What
about
are
Mexican
women supposed to do? Here's something else we know.
Between the U.S.
Lawyers
and
at the
Cuba.
ACLU have already filed suit
Presidential nominee Donald Trump.
Huge difference.
following the announcement oil prices.
Nobody's talking about this story because it's garbage.
Real, genuine, and significant change.
At least least 58 women have come forward with accusations that comedian Bill Cosby raped or sexually harassed him over a period spanning 5 decades. So far, the only criminal case against Cosby that's moved forward involves Andrea Constant, a former employee of the Temple University basketball team, who claims Cosby drugged and sexually assaulted her in his home in 2004. So here to discuss whether more criminal charges may be on the way for Cosby is attorney Gloria Allred, who represents dozens of Cosby's alleged victims. Gloria, if the claims are true, how has Cosby been able to keep this predatory behavior for so long? How has he successfully done that, which he absolutely has?
Hi, Mike, and thanks for inviting me. Also, I want to add that, yes, that is the only criminal case that is pending against Mr. Cosby. However, there are also several civil lawsuits filed against him. For example, I am litigating a case on behalf of Judy Huth, who alleges that in her lawsuit that Mr. Cosby sexually assaulted her, committed an act of sexual misconduct against her when she was only 15 years old at the Playboy Mansion. That's an allegation of child sexual abuse, and we are litigating that. Having said that, to answer your question directly, many of the accusers did not file a police report with law enforcement, did not proceed to assert their allegations or claims against Mr. Cosby in any civil lawsuit. And for many of them, and I do represent many of them, but not all, they believed that, in fact, no one would believe them, or they were in fear of making any allegations against Mr. Cosby because he was rich and powerful and famous and well-respected type of father figure, which is what he portrayed in his television persona. And they feared that they would suffer repercussions or retaliation by either Mr. Cosby or his supporters if they made such claims against this celebrity. So that is, in fact, what they allege is the reason that they did not come forward earlier, or they may also have felt that somehow they were responsible, blamed themselves, as often victims do, even though they were not, in fact, responsible for what happened.
How would you describe the pattern that you see in these civil cases that you're working? Let's put Constant aside right now, and let's just talk about the pattern that you think you have seen in the civil cases when people come to give you the facts of their case.
In terms of the common plan, scheme, or design, which is what the prosecution in the criminal case has alleged in their motion, because that motion is filed because they want to have 13 other accusers other than Ms. Constant be permitted by the court to testify in the criminal case in order to prove a common scheme, plan, or design, or an absence of mistake by Mr. Cosby in terms of that the allegation by the prosecution is that he wasn't mistaken about whether Ms. Constant consented to sexual contact with him, because if, in fact, he had a common plan or scheme of drugging women or incapacitating them through alcohol or alcohol and drugs, then he would know that they couldn't consent to sexual contact if, in fact, they are incapacitated, unconscious, unable to say no. And so that's an interesting issue that the court will soon decide. That is, whether other accusers, all, some, or none of the 13 that the prosecution would like to have testify at the trial will be, in fact, permitted to testify. We expect that decision probably in January at some point.
Well, Gloria, over the years, you've had such a huge impact on women's rights cases similar to this, just like this in many regards. But in this case, you actually, I think some of your work actually changed the law in California, where they changed the statute of limitations. They were able to make some positive changes to where women could bring these cases, because so many times statute of limitations on rape cases, it's impossible for the victim to really come forward because they're excluded. The case is excluded. Your work has been successful in changing a lot of that. What's your take on that issue in general, the use of statute of limitations on rape cases?
The statute of limitations in the United States is for allegations of sexual assault or rape is different in every state, and is different for criminal versus civil, and is different if it's an allegation that an adult was sexually abused or that a child was sexually abused. So to make it very, very simple, what we've done is we have gone to various states ever since this Bill Cosby situation developed. And many of the accusers say that it's too late now for them to do anything, and therefore they can't do anything of a legal nature, although, of course, there's no statute of limitations in speaking out against what is perceived to be injustice. So we've gone to Colorado, we've gone to Nevada, and there we were successful with the huge assistance of some of the accusers, and we have been able to change the law to lengthen the statute of limitations, the time period for criminal prosecution of rape and sexual assault. And after that, we went to California. We testified in the legislature. I met with some of the governor's representatives. And, many of the accusers, some of whom I represent, also testified and spoke out. And because of their courage, we were able to go for what I call the whole enchilada. We didn't want to extend it in California for criminal prosecution. We wanted to eliminate it. And we have been successful, and I give a great deal of credit to the accusers and also to our governor, Governor Jerry Brown, who had the vision and the foresight and understood how important it is to eliminate that statute of limitations in the future for criminal prosecution of rape and sexual assault, and he signed the bill into law.
Well, I got to tell you, in a David and Goliath combat scene, I'm going with you every time. Gloria Allred, thank you for joining me. Good luck out there. You've made such a huge difference in your career already, and this is an important case. Thanks for joining me.
Well, thank you. We're 40 years for women's rights. We've been fighting for them, and we're going to continue for as long as God gives me this gift of life. Thank you.
It might be the world's first murder solved by artificial intelligence. Police in Bentonville, Arkansas have served the online retail giant Amazon a search warrant for recording that might have been captured by the company's digital assistant, Alexa. And that was during the night of a murder. Here to give us details about this case and how these devices could change the future of solving crimes is Molly Barrow, a legal journalist for the Trial Lawyer magazine. Molly, I first briefly outline what happened in November of 2015 to Georgia police officer Victor Collins and why police think Amazon's digital assistant might be the key to solving this crime.
Well, Mike, this is such an interesting case. Police in Bentonville found Victor Collins dead, face up in a backyard hot tub. They were immediately suspicious because there were signs of a struggle, including bruises and blood on Collins' face and around the hot tub. The patio also appeared to have been hosed down. Well, the homeowner, James Bates, claimed that his death was an accidental drowning. He told police he woke up and found Collins that way, saying he'd gone to bed the night before while Collins and another guy stayed in the hot tub. But police, they didn't buy his story. They believe Collins died after a fight while being strangled and held underwater, and Bates was the only person home at the time. Well, they gathered evidence, including the Amazon Echo, which is, as you know, a digital assistance device that was playing music near the hot tub when police got there. It has the capability of recording audio, and police served Amazon with a search warrant, hoping that the device might reveal some clues to the crime.
Well, where exactly is this audio stored, and what's been Amazon's response to this request? It's kind of creepy when you think you may have a device in your house that hears everything. What's their response?
Yes, it is kind of creepy. The Echo, as you mentioned, and other devices like it are always listening through a microphone because they're waiting for a voice command. They want you to tell them what to do. Well, it records those commands, and in some cases, other audio it thinks is a command. To the device itself is where it's stored, as well as to a cloud service. Well, even if it's unlikely that the Echo captured evidence related to Collins' death, police wanted to check it, but Amazon has refused to comply with their warrant, saying the company objects to, quote, inappropriate demands related to customer information. It's important to them to protect their customers' privacy.
Well, that should concern anybody that, first of all, they don't want to give this up because that's telling you that maybe they are recording some information that we aren't aware of. But let me ask you this. Are we likely to see these kinds of devices play a role in solving crime in the future? What's your take on that, Molly?
It's going to be interesting. I don't see law enforcement agencies stopping asking for this information because it's come up before in other situations, but it's going to be an uphill battle for law enforcement because the big issue here is privacy. Tech companies like Amazon, Microsoft, and others that market these digital devices insist that they're not always recording, but not everybody believes that. Other law enforcement agencies have petitioned tech companies for information related to crimes, including terrorism, but these tech giants, they're not giving them any leeway. They're taking a stand against these warrants and these requests, and in fact they're taking steps to make it even more difficult to access personal information on a variety of tech devices, even with faced with a warrant. So it'll continue to come up, but it'll be interesting to see where it goes.
Molly, what an interesting story. Thank you for joining me. I appreciate it. This we haven't heard the last of this story, I can assure you. Finally tonight, more good news. Our neighbors to the north are about to receive one of the biggest consumer settlements in Canadian history. Auto giant Volkswagen has agreed to pay more than $2 billion to drivers of certain VW car models for rigging the emissions data of vehicles with diesel engines. You might remember that in 2015, the EPA found that VW was using software to cheat mandatory emission tests, meaning that what was happening is cars were emitting as much as 40 times the legal limit allowed for toxic nitrogen oxide. So where does that leave us? Where it leaves us now is that we have, because of the emissions defect, VW car owners saw the value of their cars drop like a rock. Because of that, these people, because of this settlement, will be able to get paid back some of the tens of thousands of dollars that they lost because of this fraud that was created by VW in the process. My prediction is that we're going to see more criminal indictments. I don't think that they're far off. This is a big story. I'm Mike Papantonio. Thank you for joining America's Lawyer. Thank you for being here tonight. Be sure to follow us on Twitter at America's Lawyer. And watch our episodes online at youtube.com/RTAmerica. Next week, we'll bring you more stories that corporate media is too terrified to tell because their advertisers won't let them. Thanks for joining me.